Peace and blessings, everyone. It's December the 19th, the year 2017. Got a letter here from Daniel Riley. I have already put it on yearofjubilee.com, so if you go to the Ed and Elaine Brown page, you can download it and read it yourself. The title is Daniel Riley, August the 13th, 2012, David. And then it was looks like it has information about the CMU. It's a fairly long letter. It's going to take me a while, but I'm going to get through it as quickly as I can. If you don't like to hear me read it, please go to the website and download it yourself. But let's get started. We have quite a bit to go. It was written in Terre Haute, Indiana, August the 13th, 2012. It was to David. So this is another recovered letter that was lost and is now found. We give God the praise for that. On August the 7th, I received your letter dated August the 3rd, 2012. I must admit your letter is a little rough around the edges, but nevertheless, it still bestowed upon me the aptness concomitant with receiving a letter from one of the Michigan crew, to which I must say I am grateful. It suffices to say, I am taken by surprise that the enemy let your letter through, seeing it mentions other prisoners' names and the like, which has been a guise to reject previous letters. Thus it smacks of the enemy having an ulterior motive. The enemy's government is despotic, which it instills in it the trait of paranoia. Therefore, it is constantly looking to construe any actions into a conspiracy against its power. Always keep this thought in the front of your head, and with that thought in mind, be conscious of your choice of words. To begin, I will address your tactical suggestion of intervening in court cases, which is well taken. I have moved to intervene in one case already, but was denied. Looking back with the perfect vision of hindsight, my intervention motion was poorly done. It could have been done in such a way to have been successful. Not to go into the details, the case I tried to intervene in is the case where the Center for Constitutional Rights is suing the Bureau of Prisons and various employees of the Department of Justice for violating the procedural due process rights of prisoners who are secreted away in this so-called Communications Management Unit, CMU. The point being, I am aware of intervening into cases. As of this moment, I am not pursuing any interventions. Please allow me the liberty for a moment to remark on this tyrannically conceived, rotten, and windy egg which has burst forth into a CMU. A CMU is tantamount to administrative segregation. Since you have been behind the wire spin at MDC Brooklyn, I have been in the hole, for just under 4 years. The enemy tries to sell the CMU as a special confinement unit or self-contained general population unit or a housing unit to control communications. Stick around for a while. I'm sure the enemy will come up with another nomenclature. Only falsehoods are capable of the infinite variety of combinations, but the truth has only one manner of being. Ostensibly, the enemy believes me to be Alice, because they have put me in Wonderland, an imaginary place that doesn't exist. The fact is, which I believe the enemy will admit without dispute, I am in an unregulated prison. The enemy may interpret the evidence as it may, but the fact must steadily be borne in mind that no regulations exist to administer a CMU. A CMU doesn't even exist in any regulation. This monster was hatched from a Warden's Institution supplement, contrary to law, primarily the Administrative Procedures Act. The regulation must come first before the institution supplement can create a new type of prison unit. It is complete lawlessness. In fact, the first law of all laws is to respect the laws. What the enemy has done by unlawfully creating this prison meets the very definition of tyranny. That is, claiming authority without a right to it, meaning the enemy's government has placed itself above the law. That is enough on that head. I want to briefly comment on a few of your statements. Yes, I did get an inordinate sentence, seeing I have done nothing unlawful, and the enemy's government engineered an unfair trial, which I will touch on in the pages that follow. David, I have to, with all due respect, disagree that all federal employees are the enemy. Common sense tells us that it is not tells us that is not correct. Rebellion must be in opposition not to persons but authority, and those federales who misuse or usurp authority are our enemy. I believe there are federales who would not follow unlawful orders and do the right thing. Maybe not many, but even one takes us out of the context of using the word all. God wouldn't destroy Sodom and Gomorrah for the sake of one righteous person. This example should suffice to render the point I am trying to put forth, not to prejudge, but to base your opinion of people on their merits and actions. With that said, do not be afraid to openly hate what is immoral or evil, and to hate whatever institution, corporation, or individual which is doing the immoral, wrong, or evil thing. David, your opinion of the Nazi informant may or may not be accurate. I know not what you base your opinion on. I can tell you he was a morally sound individual, as far as I could tell, who sacrificed 3 years of his life for the common cause and should be back on the front line soon. The way I see it, regardless of our different point of view of certain issues, each American needs one another to unite against the common enemy of liberty, the national government, and the enemy of my enemy is my friend. Moving on, continuing to address your letter. Yes, I am here with the Taliban guy. We have spoken briefly, and that is it. As far as the Al-Qaeda goes, I have no opinion, but I can say these Islamics in here that supposedly were to blow up this building, were to blow this building up or that bridge or whatever the case may be, seem awfully dim in intelligence to be capable of what they are accused of doing. And lastly, I do not have a subscription to Prison Legal News. At this point, please permit me to excuse me. At this point, please permit me to add a brief update on my current court proceedings. First, my 2255 motion has been timely submitted. I raised 6 issues, with 2 more possibly pending, upon the court granting my motion to amend to IAC. Upon the court granting my motion to hold on just one second. To amend, I have 2 issues pertaining to ineffective assistance of counsel, IAC, one being in regards to the first attorney having a conflict of interest, that being he was just months prior working as an assistant U.S. attorney, and the very U.S. attorney's office that was prosecuting me and was good friends with the 2 assistant U.S. attorneys prosecuting my case. In the first place, I never wanted an attorney, but this attorney used chicanery to deceive me into letting him represent me by promising me that he would get me pre-trial release. Everything he had me do benefited the enemy, to my detriment. After about 2 weeks, I realized I had been had and refused to acknowledge him. Thus, the court forced another attorney on me after I repeatedly motioned to represent myself, but was denied repeatedly. This second attorney I refused to acknowledge too. Eventually, 3 months prior to the trial, the judge finally let me represent myself. At least that is what I thought. Keeping a long story short, all the evidence I developed on my own and was sent to me at the county jail from people all over the country was stolen by the enemy. After 5 motions for witness subpoenas, all were denied. The last one, 10 days before trial, I motioned to present a defense theory of good faith self-defense against imminent unlawful excessive force, UEF.
Rated 1 I found is Texas Campo Karate on Faith and P. Lucas Senior Boulevard in Mess.
I got this dang phone here and it picked up on some word I said. I motion to present a defense theory of a good faith self-defense against imminent unlawful excessive force, UEF, only to be denied by the court, even though such defense was viable, meaning rooted in law. Under these circumstances, 6 days prior to trial, at the final pretrial conference, I told the court I had no choice but to turn my defense over to standby counsel and involuntary relinquishment of my right to self-representation. As I stated in my motion for the record, standby counsel, now full counsel, immediately moved for a continuance, stating on the record that he was unprepared, but was denied. I went to trial with an admittedly unprepared attorney who had no clue about the case. The show trial was just that. My attorney presented no defense except for the generic defense. He presented his defense, not my defense. My defense was simply telling the truth. At trial, several defense witnesses pled the fifth, which seemed odd to me at the time because I had spoken to them prior to trial, and they averred their willingness to testify. Unbeknownst to me, they had been threatened by the enemy that if they testified, they would be indicted, and thus intimidated their free will to testify out of existence. I didn't find this out until 3 years later. Page 3. The 2255 motion is looking very formidable because of the amount of hard evidence I have supporting it. Two of the threatened witnesses have given me affidavits detailing how the threat of indictment prevented them from testifying and what they would have testified about, showing they had relevant testimony. A third witness I have an email from describing how the threat of indictment kept him away from the trial. He is still too fearful to give me an affidavit. I am hoping, since the statute of limitations has run out, this gentleman will provide me with an affidavit. His testimony was crucial to prove UEF. UEF, what's that stand for again? Hold on. UEF stands for unlawful excessive force. Seeing he was physically attacked by the enemy. The coup de grace piece of evidence is my trial attorney has come clean by giving me a 4-page affidavit detailing his ineffectiveness. He did no investigation at all, zero zilch. Did not review discovery. Emails introduced at trial were never turned over to the defense, but his lack of familiarity with discovery caused him not to do a Rule 16 objection, which would have probably resulted in a mistrial or suppression of the emails. I named 13 witnesses he should have interviewed pre-trial and what their testimony would have been and how it supported my defense. He also admitted he failed to consult specific experts that were needed, example a law enforcement expert, to give his opinion that indeed the action taken by the enemy to end the stalemate constituted unlawful excessive force. Case law precedent says the court must give weight to an attorney's affidavit declaring his ineffectiveness. Thus I placed an anvil on my side of the scales of justice when I attached his affidavit to my 2255 motion. He is willing to testify at an evidentiary hearing if and when it is ordered. Every case I have read where the trial counsel admitted he was ineffective, which is not many, has been overturned. As you must be aware, rarely does an attorney admit his ineffectiveness, but this attorney, having now seen all the evidence, realizes I am innocent, and his conscience cannot leave an innocent man in prison. I have also raised that I was denied the ability to represent myself. Everything I claim is backed up by the record or hard evidence. For example, the AUSA admitted on the record that I had an inordinate amount of disc. Oh shoot, hold on just 1 second. Okay, let's pick back up where I left off. Sorry about that. That was my mother calling. You got to answer the phone when your mother calls. All right, let's see. Where did he say about I had an inordinate amount of disc being sent to the county jail, so they cannot say I made it up, that my evidence was stolen. Plus, I have numerous property receipts showing the disc arrived. You see, the disc would arrive. The jail would not give them to me, but instead would put them in my inaccessible property, sometimes giving me a property receipt. All in all, 17 to 22 discs disappeared with exculpatory evidence on them, and the potential to develop other witnesses form these discs, seeing that literally thousands came to the Browns' home in New Hampshire after I involuntarily surrendered my self-representation 10 days. 10 days later, the judge issued the subpoenas that I had been asking for over 4 months, thus proving my self-representation was being used against me, thus forcing me to relinquish it. Without my evidence or witnesses, I could not present my defense, and besides, the judge would not let me present my 100% lawful defense. I filed a motion to present my defense, and it was rejected with one word, denied, proving I was denied my defense. In sum, these deprivations made my self-representation a hollow sham. When I see someone celebrating the 4th of July or exclaiming the land of the free, I say to myself, look at that fool. He obviously has never been in federal courtroom. The two amendments are a Youngblood claim for the stolen evidence on disc and a Brady claim for refusing to turn over the weapon receipt. On June 7, 2007, the enemy stormtroopers tried to murder me by opening fire on me as I fled. This was captured on video. During discovery, I got the enemy to turn over the video, but they altered the section of the video where the shooting occurs. This video should be on YouTube, which is a felony of evidence tampering. The enemy lied by fabricating the use of force reports, UFRs, to make it look like they shot at me with 37mm launchers with less than lethal bullets, when in reality they shot at me with deadly 5.56 gunfire, just missing my grape. I knew the UFRs were fabricated, but I needed the weapon receipts to prove it. The weapon receipts were the knockout blow to their whole case of lies. They would have been the key to proving beyond any credible debate that unlawful excessive force was being used, and that the enemy knew what they were doing was unlawful and they were trying to cover it up. Not only did they try to murder me in June of 2007, but on July 28-29th of 2007, the enemy attacked us by shooting about 35 rounds at us for no apparent reason, except to try and provoke a firefight. This is the night they attacked the gentleman who is still too frightened to provide me with an affidavit. This event proves the UEF unlawful excessive force was imminent, not to mention the helicopter assault on July 14th, 2007. The key was to show the jury all the UEF, then all my actions are painted in a different factual landscape for the jury. My actions become reasonable, they become justified, and they become lawful. I have since filed a Bivens lawsuit against the jackbooted thugs, JBTs, who tried to murder me. The case has been pending since March 20th, 2012 on the defendant's motion for summary judgment. If it is denied, I expect a trial shortly thereafter. During discovery in this case, guess what? I finally received the weapons receipt I've been seeking for 3 years. The receipts prove what I have been saying for 4 years. They fired at me with M4 5.56mm rifles, which is the exact weapon listed on the weapon receipts, which means that was the weapon they were issued and were carrying that day. It also means they committed felonies when they falsified their use of force reports. Not one shred of documentary evidence connecting either shooter to a 37mm launcher has ever been produced. The excessive corruption in the national government is really so way over the top now. What gets me is I never hurt so much as a fly. I never threatened anyone. I never pointed a weapon at anyone. I never attempted to stop the marshals from doing anything or ever said I would try to stop them. In fact, I said the opposite, but I do have the lawful right to defend other Americans from unlawful excessive force, and the enemy calls me the bad guy. I just don't get it. Wait, I have another lawsuit, a Bivens against the U.S. Attorney and former U.S. Attorney of New Hampshire, along with an assistant U.S. Attorney. More corruption. The enemy seized all my liberty tools when they captured me. They added a forfeiture count to the indictment. During trial, they paraded my liberty tools in front of the jury every day, only to never use them during the trial, meaning they failed to show the jury I used my tools in any way connected to a crime of violence. Thus, they never moved to have the jury forfeit them. Instead, they initiated a civil forfeiture proceeding unbeknownst to me. I found out a year and a half later, after my tools were default forfeited. I moved to reopen the case on the grounds I was never served notice. The scoundrels presented fabricated certified mail documents to make it look like they notified my trial counsel. Needless to say, I lost my bid to reopen the case on appeal too, due to falsified postal documents. Eventually, I sent the photocopy of these postal documents, one being the return receipt, and my trial attorneys printed and assigned signature on it. Prior to this, the attorney and I had never discussed the forfeiture proceeding. The attorney called me on February 17, 2012 and told me that he never received any notice of forfeiture and that someone had forged his name on the return receipt. I was blown away. I probably should not have been, knowing just how corrupt the national government is. Upon further investigation, the Postal Service has no record of the 16-digit tracking number ever being used, and that comes from the Postmaster General's office in Washington, D.C. My claims are for procedural due process, equal protection, and civil conspiracy. I passed out court screening, and the enemy's answer is due this week. They have no plausible defense that my imagination can think of. My objective is to get them disbarred once I obtain the judgment against them. I sit here in this cage thinking all the felonies the enemy has committed against me and how they have violated the public's trust, and yet they deem me the threat to the public. It just boggles my mind. I will admit I am a threat. Is not the truth always a threat to lies? All I have to offer is the truth. My dad taught me early on the importance of not lying, to always tell the truth, because that is what is right. His aim, it appears, was to instill in me not to choose the right, but to become a sort of person who cannot choose the wrong, and thus have no choice in the matter. Simply love the right because it is right, and then you cannot choose otherwise. Thus you cannot be the cause of evil. My dad also taught me how important justice is. I remember my oldest brother Chucky took my brother's Bill's coat because it was bigger, fit him better, and even though the coat Chucky gave Bill fit Bill, Bill wanted his baggy coat back. I was made to decide the issue by my dad. I ordered the matter should stay because both seemed better suited. My dad overruled me, saying that I considered convenience, whereas justice ought to have been first concern, and justice teaches that no one should suffer forcible interference with what rightfully belongs to them. Little lessons like this stuck with me for my life and keeps my dad alive through me. My dad was truth and justice in the American way type of guy, but now America has lost its way. The national government is no longer the people. It's the bankers and the rich elite's government. This is why it is corrupt, with injustice and plagued with liars. Let us turn our thoughts to other subjects. Let us consider in what we could contribute to the progress of real and substantial liberty, and which is to be sought not from without, but within ourselves, and is to be obtained principally not by fighting our enemy, but first using the laws, working within them to roll back the assaults on liberty and to struggle against the enemy with reason, explaining to the enemy's government how it has violated the public's trust. For example, it is irresponsible borrowing and spending, which it refuses to correct, causing harm to the sovereign people, and with admonition putting it on notice that its evil ways can only be tolerated for so long, and with prayer poured forth to God, with whom alone justice flows from. In our country, the people are the sovereign, not the government. The people are collectively made up of citizens who each share in the sovereign power, but at the same time each citizen is a subject, being under the laws of the state. The words subject and sovereign are identical correlatives, meaning they reciprocate and are mutually related, the idea of which meets in the single word citizen, which comes from the ancient Greek for the name of the members of a city-state. What is a government? I could be wrong. An intermediate body set up between the sovereign and the subjects to secure their mutual interaction and charged with executing the general will of the sovereign found in laws and the maintenance of liberty, both political and civil. The government is so the nation may give its decisions force, but in delegating the powers necessary for the execution of its will, it does not abandon any of its supreme authority. The people or nation remains sovereign and can at any moment at any moment recall the grants or delegations it has made. Government, therefore, exists only at the sovereign's pleasure and is always revocable by the sovereign's will. The government is distinct from the body of the state or people, with its own members acting in concert to fulfill the ends for which the sovereign set it up. It has its own personality and consciousness made from its members, and a force and will of its own, which always ends up being used for its self-preservation. This force and this will is distinguished from the public's force, that is, the militia, which is destined to the preservation of the sovereign people, nation, society, and in a word, is always ready to sacrifice the government to the people, and never sacrifice the people to the government. The general will, that is, the will of the majority of the sovereign, is no longer being able to penetrate into the government. Instead, that which prevails is the will of private interest being carried through by two corrupt factions. Nothing is more dangerous than the influence of private interest in public affairs, which is rampant at this point in our beloved country's history. The worst being that den of vipers over at the Federal Reserve. Our country's condition is not sound, but rotten. The sovereign people have tried to stop the government through every conceivably peaceful channel, from trying to control the world in its ceaseless busybodiness in every country's business, ceaseless wars, ceaseless borrowing, ceaseless overspending, ceaseless liberty robbing laws, and ceaseless plundering of the people through printing irredeemable paper promises. The government has become a common pest and a destroyer of the people's liberty. Stated differently, it is the author of the people's ills. The government knows the people are murmuring along with the groans and lamentations of their loss of liberty, and wanting something done to counter the government's growing tyrannical nature, which is incrementally dispossessing the sovereign American people of their natural and civil rights. Indeed, the private interests who control the enemy's government want to make it the master of the ship, of which it is only rightfully the pilot. The pages of history inform us that every government in the world, once clothed with the public powers, sooner or later usurp the sovereign authority. Usurpers always bring about or select times of trouble to get past under cover of the public terror. Destructive liberty-robbing laws which the people would never adopt in cold blood. For example, the misnomered Patriot Act and the Anti-Terrorism and Effective Death Penalty Act passed immediately after 9/11 and the Oklahoma City bombing, respectively. The moment chosen to foist these bad acts on the people is one of the surest means of distinguishing the work of a legislature from that of a tyrant. These laws are always sold under the pretext of the public good, which has always been the most dangerous scourge of the people. It is the natural and inevitable tendency of even the best constituted governments to form separate and distinct interest from that of the sovereign people and for their representatives, which is another misnomer, to sell their fellow countrymen and women over to slavery for their own selfish personal interest. I could go on reasoning how and why the enemy's government is despotic, backing it up with objective facts, but since I feel my reader is of the choir, there is no need to preach at this point. It has turned from a free government, our government, to our enemy. A free government in a word, but an enemy indeed. Is this statement irrational? When those who acquire great power for themselves to the destruction and ruin of the people should not be called a government but enemies, and in my humble opinion, seeing they do things which enemies do, they should not be appeased by any truce. For those who do harm under the guise of governing are far worse than open enemies. The sovereign people are not in rebellion when they resort to force to restore the government. As long as they first exhausted all due means of redress, then, therefore, the government becomes lawfully declared despotic, and it has no more right over its citizens than a master over his slave. And the question is one purely of might, and at that point the government has forced the people to undertake a war in their just and unlawful defense of their liberties. The government ought not resist the sovereign people, and if it does, it is just further proof that the government is despotic. Let all the right-minded, sensible American people reflect and ask themselves and one another, are we at this point in our history? I believe we are. What doctrine, what law, what religion ever instructed men and women so that they should prefer to leisurely stand back and watch themselves and their posterity be enslaved rather than go confront the enemy? What is there that can make it more incumbent upon us to be not ferocious and barbaric, but courteous and humane? Our duty is not to sow and reap war, but to cultivate peace and safety for all. But sometimes your hand is forced by the uncontrollable actions of our enemy. Like when a burglar enters your castle, his actions forced you to shoot him in self-defense. The same applies to our current situation. What reason for waging war is more just than to drive off slavery? And indeed, if we consider the proper use of war, what can be more becoming in citizen soldiers who are enlisted and embodied for the express purpose of being the guardians of justice and the defenders of liberty, and to uphold the legacy of the 1776 generation? I ask, is there a question about the lawfulness of raising war against a tyrant? Are not the Syrians doing it today and the U.S. government condoning it? The enemy's government and their mass media has an objective to make the people immoral, unvirtuous, poor, weak, and wretched, so they are unable to resist their enslavement. I see the people all running headlong to their chains in hopes of securing their liberty. As they are lulled to sleep in a bed of security, we have nothing to show for ourselves but a frivolous and deceitful appearance. Honor without virtue, pleasure without happiness, rights without enforcement, and liberty without rights. Shouldn't we all be concerned that the window of opportunity is closing, or is it already closed? Congress appears to believe it has closed by virtue of the laws they pass. Politicians attribute to men and women a natural propensity to servitude, because the slaves within their observation are seen to bear the yoke of slavery with patience. The value of liberty is known only to those who possess it, and the taste for it is forfeited when liberty itself is forfeited. Slaves lose everything in their chains, even the desire of escaping from them. Is this the current mindset of the sovereign American people? I pray to the Lord of armies host that it is not. Have the people become so greedy, cowardly, and loving ease more than liberty? If so, they will not hold out long against the redoubled efforts of the enemy's government to fully complete their objective. The enemy's progress towards our enslavement has been allowed to get too far along. The sovereign people should react like an unbroken horse who erects his mane, paws the ground, and starts backing up with impulsive vehemence at the first sight of a bridle. This is how the people should react to every single liberty-robbing law that is proposed, let alone passed into law. And if passed, it must be thrown off like a rider who attempts to bridle our unbroken horse. By contrast, the people have been foolishly acting like a properly trained horse who suffers patiently for the bridle and even the whip and spurs too. The legacy bestowed upon us Americans by the founding generation is to never submit our necks to the yoke of slavery, but instead we prefer the most turbulent state of liberty over the most peaceful slavery. Must we remain passive victims of federal tyranny? Our venerable forefathers, we must observe by recollection and sacrifice pleasure, peace, treasure, blood, and life itself to give us the jewel of liberty. Is our generation the one to be cursed in our graves by our posterity for idly sitting by as the chains of slavery were forged, then applied? I have no more to say on this head at present. Few words will save us. Moving on, you asked if I needed anything. To that, I answered yes. I respectfully ask you to post this correspondence in full on the internet. I believe my political views have an audience out there. A little background information. I've been voicing my political speech in correspondence like this to various individuals. I then send a copy to a female patron in Indiana who you got my address from to be posted online. She has been having problems posting my letters. I've been waiting 3 months for her to post 3 letters I wrote in the spring. Even though I cannot afford to photocopy and mail this, I'm going to send her a copy of this correspondence in hopes she has resolved the posting problem. If not, I would ask you if you could be an outlet, a place for me to get my political speech to the people. Please contact her and find out the situation with getting my letters posted. This is the first letter I wrote since May. I've been idle, waiting for the posting issue to be resolved. If she has resolved the posting issue, then never mind, disregard. But if not, tell her to email you my previous correspondences. There should be 5 of them, and she should have them all scanned into the computer because my brother emailed them to her. Now, if you cannot post them due to whatever reason, that is fine too. Eventually, I will find a place to reliably post my political speech in order to help prepare the public's mind. I always thought correspondences like these would be a good source of information to keep a blog active or a website active. Seeing I was averaging 2 a month before the posting issue began, in the alternative, maybe you or your female friend in Indiana may know someone else who would be interested in carrying my political speech. I prefer Indiana, but if she cannot fix the posting issue, I have no choice but to seek an alternative. Hopefully it is fixed, but like I said, if not, can you please get my letters posted? I'm sure Indiana will forward the previous letters to you, and if she is having problems with her email, because I know she has a lot of electronic issues some of the times, feel free to email my brother at something.com, and he will email them to you. I believe it is my duty to speak in season and to forewarn my country in time. I also believe my letter has become too prosy to you. Therefore, I will end by simply saying, take good care. And that's from Daniel Riley. All right, I think his letter is always powerful. I pray you get a chance to distribute this and get the word out. Thank you for your time. Please write a letter to Daniel Riley and let him know that we care about him and love him. Thank you for your time.